everyone, welcome back to Legalese Translator. My name is Heather Hui-Litwin, and joining me here today is Heather Douglas. Hi, Heather.
Hi.
So in this video, I'm going to ask Heather to explain what the word damages mean. Heather, if you could enlighten us on that.
People can sue in court for a variety of remedies. For example, one remedy is an injunction, another one is asking for specific performance. Damages is another remedy that people can ask the court for. And it's the most common form of remedy that we see claimants seeking in the courts. When you're asking for damages, you're essentially asking for money. Damages are a form of a monetary award to be paid to the plaintiff to compensate for a loss. And there are two types of compensatory damages. Compensatory damages can be categorized into special damages and general damages. Special damages are damages that are capable of exact calculation. For example, medical expenses, property damage, loss of income, those are all considered special damages because they can be easily calculated. General damages are not capable of an exact calculation. For example, that would be pain and suffering. If you hurt yourself in an accident, your pain and suffering would be considered general damages. But all the medical expenses related to seeing doctors, all those invoices that are related to seeing doctors, those are special damages because we can calculate them by looking at your invoices and adding them up.
Now, what about something called aggravated damages?
Aggravated damages are less commonly awarded.
Oh, okay. Usually,
the courts are looking to place people in the position they would have been had the event not occurred. Mm-hmm. And generally, the damages are meant to compensate for a loss. Aggravated damages are awarded because the nature of the defendant's conduct was so egregious, so terrible, that it caused the plaintiff additional harm. And in that event, the court will award aggravated damages.
Are aggravated damages the same thing as punitive damages?
No. Oh. So aggravated damages are meant to compensate for when there was reprehensible conduct.
Okay.
Punitive damages are meant to punish, they are to deter very bad behavior. They are similar in that aggravated damages and punitive damages are awarded in extreme circumstances when there is extremely bad behavior.
Right. I see. So it sounds like there's a little bit of that deterrence and punishment aspect in civil litigation. Now, one final question. I've heard that there's something called nominal damages. Like, can you explain a little bit about that?
Yeah, nominal damages are an award of usually of a very small amount that's meant to reflect when a tort was committed, but there was actually no damage. So for example, maybe someone trespasses on your property, but nothing happened to your property. The court, maybe they'll give you $500 just as a nominal award to say, okay, something was committed, but you really didn't suffer any harm.
Okay, so I lied just now. I do have one final question. So for the aggravated or punitive damages, if you don't put that in your statement of claim, and yet, you guys went to trial, and it was apparent to the judge, that the other side has conducted themselves very irreprehensibly. Would the judge of his or her own accord award aggravated or punitive damages, even though you didn't actually put that in the statement of claim?
The Superior Court has inherent jurisdiction,
Okay.
and they have the right to make orders beyond what the parties have asked for. But that's extremely, extremely rare, because the courts want litigants to have notice of the claims being made against them.
Right.
And if you're not going to seek a specific form of relief, it is extremely unlikely that a court will give it to a litigant. So you have to be incredibly careful with your pleadings to make sure that you are asking for everything that you want, and not to rely on the discretion of the court.
Can you not ask for this in the middle of trial?
Pleadings can be amended at any time, subject to some exceptions. So you can, if you realize you've missed out on pleading for a specific form of relief, you can ask for it later on.
But theoretically, you could ask for this in the middle of trial.
Yeah, you can ask for it in the middle of trial, but I wouldn't recommend that.
It's not a good idea, right?
No. It's better to know your case before trial, and to know what you're seeking before the trial happens.
Right,
That's always
of course.
best practice.
Yes. Yeah, I think.
But sometimes things pop up, and you need to make an amendment. And
no, I think absolutely. Yeah, I agree, because I think that it's important for people to know that in our civil litigation system, it's really meant to be fair, and you really shouldn't be trying to bring up surprises in the middle of trial. Yes, right. So thanks everyone for watching. If you're new to our channel, don't forget to hit the subscribe button and also the bell, so that you can be notified of our upcoming videos. And we hope to see you at the next video. Thank you. Bye-bye.